Washington on June 6, the administration of President Donald Trump requested the Supreme Court to allow it to dismantle the Department of Education and terminate hundreds of its employees. President Trump aims to fulfill his campaign promise to eliminate the Department of Education and transfer school policy control to the states. In an emergency appeal, the administration argued that the court should overturn a judge's order preventing Trump from executing these plans while they are being contested by states led by Democrats, school districts, and teachers' unions. Solicitor General John Sauer emphasized to the Supreme Court that the Constitution grants the executive branch, not district courts, the authority to determine the number of employees needed for an agency's statutory functions and who those employees should be. U.S. District Judge Myung Jaun ruled that the White House's decision to terminate over 1,300 employees in March hindered the federal government's ability to effectively implement legally mandated programs and services. Jaun stated that such changes require congressional approval, as Congress established the department in 1979. The Boston-based First U.S. Circuit Court of Appeals upheld this decision, noting that the administration failed to provide evidence countering Jaun's findings on the negative impact of the mass firings and the transfer of some functions to other agencies. Judge David Barron, writing for a panel of three circuit judges, highlighted that the case concerns whether a nearly half-century-old cabinet department can carry out its assigned functions or be obstructed by a mass termination of employees aimed at effectively closing the department. An executive order signed by Trump in March directed Education Secretary Linda McMahon to facilitate the closure of the Department of Education. Republicans have long criticized the federal government for exerting excessive control over local and state education policy, despite having no authority over school curricula. McMahon announced that approximately half of the agency's workforce would be reduced through mass layoffs and voluntary buyouts, decreasing staff from 4,133 employees at the start of Trump's second term in January to 2,183 employees. The administration also plans for the Small Business Administration to manage student loans and for special education services to be transferred to the U.S. Department of Health and Human Services. Jaun's order prevented the administration from transferring these functions and required the department to reinstate fired employees. The appeals court stated that while Trump is not required to maintain as many Education Department employees as previous administrations, he cannot reduce staff to a level that impairs the agency's ability to function as Congress intended. The Justice Department informed the Supreme Court that the harm to the government from rehiring workers during ongoing litigation outweighs any harm claimed by challengers due to diminished department services. The Department of Education is legally obligated to ensure fair treatment for students and teachers with disabilities and provide resources for low-income schools to match those of more affluent ones. It also issues regulations holding colleges accountable for preparing graduates for well-paying jobs and functions like a major bank, distributing billions of dollars to assist with college expenses. Even if the Department of Education were reorganized, which would require congressional action, its obligations under Title IV of the Higher Education Act of 1965 would need to continue elsewhere. This law, enacted during President Lyndon B. Johnson's administration, mandates government administration of student loan programs, issuance of grants, and ensures schools receiving federal funds do not discriminate against students.